Before I begin, members of the panel, could I confirm that you can hear me and see me clearly?
Yes.
Thank you, Mr.
Yes.
President. May I begin, Mr. President?
Yes, please.
Good evening, members of the panel. My name is Seah, and I'll be speaking on behalf of the Respondent, the Games Disciplinary Committee, henceforth the GDC, on the first issue regarding the GDC's quorum and a fourth issue on doping, which are Mr. Landet's issues on appeal for 14 minutes. My co-counsel, Mr. Brendan Zhang, will be speaking on issue 2 on the location of the tribunal and issue 3 on Ms. Tang's ability to participate in the qualifying games, addressing Ms. Tang's issue on appeal for 15 minutes. We respectfully reserve 1 minute for a rebuttal. Members of the panel, this case is not about sympathy for one athlete or the popularity of another. It is about upholding the rules and integrity of the qualifying games. The GDC acted within its mandate, applying the governing rules and principles to protect fair competition and ensure that the games are conducted without illegality or undue advantage. With that, I make 2 submissions addressing Mr. Landet's claims. Firstly, the GDC's quorum was not biased in coming to a decision, as both Ms. Farina and Mr. Douglas are independent and impartial arbitrators. Secondly, the GDC did not err in finding that Mr. Landet had been liable for doping. Bluebat in its nature is a performance-enhancing drug. Turning to issue 1, if I could turn the panel's attention to para 37 of the record.
Yeah, it's fine. Please go ahead. Thank you.
Thank you. What Mr. Landet intends to do is to challenge an arbitrator. To determine if an arbitrator should be challenged, the applicable rule will be Rule 34 from the CAS Code. Rule 34 states that, and I quote, "An arbitrator may be challenged if the circumstances give rise to legitimate doubts over his or her independence or impartiality." The threshold of legitimate doubt is similarly noted in Article 180 Part 1c of the Swedish Federal Act on Private International Law, which states that, and I quote, "An arbitrator may be challenged if circumstances exist that give rise to justifiable doubts as to their independence." And last but not least, and most crucially, the threshold of justifiable doubt can be found in exact wording featured in the Malaysian Arbitration Act at Section 14.3 Part A, which states, and I quote, "An arbitrator may be challenged only if the circumstances give rise to justifiable doubts as to the arbitrator's impartiality or independence." This demonstrates that the evidence of biasness must be justifiable and concrete, and the threshold has been applied stringently in related cases. The high threshold of justifiable doubts has been illustrated in a 2020 Swiss Federal Tribunal case of Sanyang and World Anti-Doping Agency. The courts noted at para 6.5 that there must be concrete facts objectively giving rise to the lack of independence. If I could first turn the panel's attention to para 4 of the record. Ms. Farina is described merely as Ms. Tang's cousin sister. While this indicates a blood relation, it is a relatively distant one. Furthermore, there's no evidence on the record that suggests any meaningful personal or emotional closeness between them. The absence of any indication of frequent interaction, shared household, or personal involvement beyond this simple genealogical link supports the inference that their relationship is more nominal rather than substantive. Moreover, although the record in para 4 mentions that Ms. Farina had provided some on-the-side coaching, this should be viewed as a limited and informal engagement. There's no suggestion that she had a permanent coaching position or received remuneration. Such ad hoc or casual assistance, perhaps in the form of general sporting advice or casual tips, does not amount to an entrenched professional association that will compromise her ability to remain impartial or independent. It is plausible that Ms. Farina's involvement was situational, incidental, and peripheral to Ms. Tang's competitive endeavors. Taken together, the tenuous familial link and the limited scope of professional contact point towards a relationship that is neither close nor influential. There is therefore insufficient basis to conclude that Ms. Farina's role on the commission would be tainted by personal loyalty, dependency, or bias towards Ms. Tangs. With regards to Mr. Douglas, the professional interactions such as the fan meet-ups as raised by the appellant, where both Mr. Douglas and Ms. Tangs were spotted together, are typical of public figures in an esports realm and do not indicate a privileged or adversarial relationship that will compromise his judicial capacity. The one-time special sharing session, which the appellant seeks to rely on, was an event that took place 6 months prior to the tournament, as seen from para 26 of the record. A single historical event, even if it led to them being remaining in contact since, does not establish an ongoing dependent relationship that will necessarily sway his judgment regarding the complex issues on doping or eligibility. Furthermore, even if there was a finding of a relationship, there must be ongoing economic ties or ties that have ended recently to demonstrate a lack of independence or impartiality. This was noted in a 2015 case of AVB heard in the Federal Supreme Court of Switzerland. At para 2.2.1, they emphasize that impartiality and a lack of independence is only found if there's ongoing economic ties or ties that have ended recently. In our case, even if we agree with the appellant that there was a relationship between the arbitrator and the party, there's clearly no economic ties between Ms. Farina and Ms. Tangs, as they are merely family members, in which Ms. Farina only acted in the capacity of a coach. Noting that Mr. Lander is the one alleging the presence of a lack of independence, the burden of proof will be on him to prove so. With respect to Mr. Douglas, there's only a coaching relationship as well, as seen from para 26. While their relationship got closer, there's still no evidence of any economic ties of which Mr. Douglas would have had profited in ruling in favour of Ms. Tangs. Lastly, we address the appellant's contention that a lack of disclosure will amount to an arbitrator being removed. This is wrong. On my first argument, a lack of disclosure does not amount to a finding of an impartiality or independence. In a 2021 case of AAV International Federation Association of Football, the challenge arbitrator had regularly failed to disclose information regarding past cases in which he served as an arbitrator. While his practice of such non-disclosure was held by the courts to be inappropriate and contrary to the requirements linked to the duty of disclosure, there was nothing on the facts that indicated that the practice was a deliberate intent by the arbitrator to conceal information. Consequently, the courts did not find that the arbitrator possessed a lack of independence or impartiality. In our case, we submit that there's no deliberate attempt either by Ms. Douglas or Ms. Farina to conceal their prior relationships from the court. Crucially, if I could turn the panel to para 27 of the facts. Ms. Farina's reason for lack of disclosure was because she had figured that such information would be public. This suggests an absence of intent to hide the association based on a belief that the information was already known or easily accessible, and therefore this negates a deliberate act of concealment. Further inference can be drawn from the public origin of Mr. Douglas' relationship with Ms. Tangs. Mr. Douglas was previously an online streamer and gamer and has been seen on occasions with Ms. Tangs in fan meetups, as mentioned by the appellant. Therefore, as his appearance in fan meetups was already in the public domain, the notion that either party maliciously tried to conceal their background relationships is undetermined. Unless I may be of further assistance on the first issue, I'll turn to the fourth issue on doping.
So, counsel, you're taking the stand that the issue of the non-disclosure, if I could just put it in very layman's terms, you're basically taking the stand that the issue of non-disclosure was no big a deal because there was no ongoing transactional relationship between the parties, correct?
No, Mr. President. That was to my earlier argument on independence and impartiality. I'm alleging that the absence of disclosure will only be found to show that there's lack of independence or impartiality if there was a deliberate intent to disclose information. In our case, there is no such deliberate intent from either Ms. Farina or Mr. Douglas.
But you are also aware of the fact, I'm just picking your brain
Yes.
on this a bit, Council.
Certainly,
because,
Mr. President.
Well, what the appellant had to say on this topic resonates with us, but there's also, that there's also two types of bias. There's the actual bias,
Yeah.
and there's the appearance of bias. Would you at least, what would you say if I were to make the conclusion that there was at least the appearance of bias here?
We understand there is appearance of bias, and this threshold was similarly noted in a 2020 case of Sanya and World Anti-Doping Agency. However, they caveated that it is important that there must be concrete facts going to this appearance of bias. And presently, on the facts that, as I have submitted, there is no such concrete facts that will even lead to the appearance of bias. Unless I may be of further assistance, I'll turn now briefly to the fourth issue on doping. Turning
Just
to the-
one moment, following up on the questions by Mr. President.
Certainly,
I
Mr.
am
Arbitrator.
mindful- Yeah, I'm mindful that you have provided us with very commendable precedents and case law from the Court of Arbitration for Sports and the Swiss Federal Tribunal and also the Swiss Supreme Court. If I'm not mistaken, the prevailing or the applicable law for this particular arbitration is the Malaysian law. So I'm wondering whether you have any legal precedent or guidance for the panel here today insofar as the test for apparent biasness is concerned.
Certainly, Mr. Arbitrator. If I could direct you to Article 28 of the CAS Code, it stated that the CAS seat is in Switzerland, and ultimately, in many CAS cases, they have applied applied cases that have been ruled in Switzerland, and while the governing law in the current arbitration is that of Malaysian law, we are still mindful of the fact that the CAS seat is in Switzerland, and this allows us to cite other relevant legal authorities that, while may not be binding on this court, is extremely persuasive for the tribunal to come to a conclusion.
Thank you.
Thank you, Mr. Arbitrator. I know my time, and I will address the fourth issue briefly. Firstly, the GDC acted within its jurisdiction and discretion under the qualifying game rules, finding that Mr. Landert had breached Rule 12 under the qualifying game rules. We note that the appellant has submitted that the qualifying game rules, Rule 12 of the qualifying game rules, should not be followed. However, they also further allege that there's no real interpretation of what spirit of the sport means. However, the definition of spirit of the sport is clearly provided inside the the World Anti-Doping Code. If I can quote it for the panel to understand, the spirit of the sport is a celebration of the human spirit, body, and mind. It is of essence Olympism and is reflected in the values of excellence in performance. Putting this in context of Quidop, is essentially an e-sport where concentration and focus is the key to winning. This is something that Mr. Landert knows very, very well, with himself coming clutch in draw-breaking games as seen at para 6 of the record. If I could turn the panel first to para 12 of the record. In the final match between Mr. Landert and Ms. Tangs, their close draw-breaking game is extremely tiring on the eyes and mind. Therefore, the player who deserves to win is the one who is able to, without any form of doping or assistance, focus all the way to the end. However, Mr. Landert was only able to win with the assistance of Bluebet. Crucially, in this very same para 12 of the record, Mr. Landert, knowing that Bluebet could keep his energy up, kept the energy drink nearby. Ms. Tangs, with a dominant performance, as seen at para 11 of the record, was bound to have won the tournament, if not for Mr. Landert's intervention with 5 points. The concentration enhancing drug essentially allowed Mr. Landert to take the edge over Ms. Tangs, as seen at para 13 of the record. Therefore, his actions goes against the very core of rewarding a player's excellence in performance, which is against the spirit of the sport. Mr. Arbitrator, I know my time, if I may have a 3-minute extension to wrap up my submissions on the fourth issue.
I have no objection to it, subject to my fellow arbiters. I have no objection.
Thank you, thank you, panel. Our second, Rule 13 of the qualifying game rules instructs that athletes have to refer to the WADA prohibited list, but the term signifies guidance rather than an exclusion. It does not preclude this commission's authority to rule under Rule 12. And earlier, I note Mr. Arbitrator, Mr. Shukri, had queried the appellant on the fact that it would be implausible to allow Mr. Landed to have consumed blueback even though it was a drug that's not listed, and his concerns are validly addressed in many other cases. In the 2004 case of Maria Louise Kelly Williams in IOC, the tribunal accepted that an unlisted substance could still fall within the scope of the code if it exhibited similar pharmacological effects or violated the spirit of the sport. Professor Caitlin's expert report, cited at paragraph 3 of the judgment, concluded that although not expressly listed, isomethapine, the substance in that case, had a similar pharmacological effect to other prohibited stimulants under the WADA code. The panel accepted that anti-doping authorities could act on such evidence to preserve fairness, and therefore, analogously in our case, blueback enhanced concentration and alertness in competition, mirroring the very harms that anti-doping rules are meant to protect. And if I may quote a very important passage noted by an arbitrator in the 2005 US and Conte case, they noted that it will be impracticable to identify all forms of steroids in a list of prohibited substances, and the restricting prohibition to certain named substances will be both unfair and detrimental to sport. This reasoning directly supports the GDC's proactive stance in developing Rule 12 as a catch-all clause, directly addressing Mr. Shukri's concern today. Lastly, we submit that the GDC has the ability to impose extra rules as compared to simply relying on the WADA code. In the 2011 case of USI and Alberto Contado, it affirmed that the WADA code is a dynamic instrument, interpreted in the light of evolving scientific understandings. At paragraph 4 to 11 of the award, it noted that the absence of the threshold of the substance in that case did not preclude violation, and confirmed that anti-doping bodies may adapt their standards to understand and encompass new discoveries. Applying the principle analogously to our case, the GDC is entitled to act dynamically under Rule 12 to allow it to be a catch-all clause to address unlisted but crucially performance-enhancing substances pending WADA evaluation. Applying these principles, the GDC's decision was reasonable and proportionate. Blueback, while not on the WADA prohibited list, demonstrably enhanced cognitive focus, stamina, and created an unfair advantage, allowing Mr. Landed to win. In conclusion, with respect to Mr. Landed's issues on appeal, the GDC maintains that the quorum was not biased, and the GDC was correct in finding that Mr. Landed had committed a doping violation. Unless I may be of further assistance to the panel.
It's okay.
This concludes my submissions. Thank you, members of the panel. I'll now yield my time over to my co-counsel, Mr. Brendan Zhang, who will address the remaining two issues on appeal. Thank you.
Good evening, honorary members of the panel. My name is Brandon Zhang, appearing for the Respondent, the Games Disciplinary Committee. I will be speaking for 14 minutes. We submit that the GDC did not err in allowing the tribunal to be set up in South Nankaland, and that the GDC did not err in deciding that Ms. Tangs is ineligible to participate in the qualifying games. If I may direct the panel's attention to paragraph 25 of the record, it states, a day after the tournament, there were massive riots against the government, and the riots subsided after 3 days. Pursuant to Rule 23, Sub-Rule 2 of the qualifying games, the tribunal shall be set up within a week from the end of the tournament in the country where the tournament was held, where reasonably practicable to do so. In the present case, we submit, given the circumstances of the case, it was a matter of safety to leave the country as soon as possible. And this is because, again, it was not known how long the riots would last, and more importantly, whether the protesters would start another riot within the same week. And therefore, it was practically reasonable to extend past the 1 week time frame. And at paragraph 29 of the record, the hearing was held in the Global Games headquarters in South Nankaland, as your honors had queried earlier. And we submit merely because it was in the Global Games headquarters. This does not mean there was any impartiality or unfairness. It was chosen as the most convenient place to hear the dispute and collect and share information amongst the relevant parties, and these parties also included the qualifying games medical team, the games committee, and the International Video Games Federation. And in addition, South Nankaland is an Oceania country, and Ms. Tangs was also born in an Oceania country, and furthermore, Mr. Landon had not objected. And your excellencies had queried earlier on the right to be heard. And according to Article R57 of the CAS Code, even if there was any procedural unfairness or process due rights infringed, those infringements are cured hereby under Article R57, and the court can proceed to decide on the merits of the case. And in addition, Ms. Tangs had submitted her written submissions at paragraph 33 of the record. Her anti-doping reports was also submitted, and there was oral submissions heard. Therefore, there has been no breach of procedural unfairness. Turning to the second submission, we submit that the GDC did not err in deciding that Ms. Tangs is ineligible to participate in the qualifying games as she held dual citizenship. Under Rule 3, Subrule 1, a person is eligible to be a participating athlete if he or she is a citizen or permanent resident of a country in Asia. And CAS jurisprudence has held that the rule must be interpreted as to discern the true intention of the rule maker. This was in the 2013 CAS case G&K Dynamo versus UEFA at paragraph 9.11. The court held that the panel has to interpret the rules in keeping with the perceived intention of the rule maker, not in a way that frustrates it. And in the present case, the GDC correctly applied the rule. The intention and underlying purpose of the rule makers was simply for the games to be represented by an Asian athlete who was of citizenship or permanent residence. And that was reflected at paragraph 33B, where the GDC gave its reasoning that she was not 100% Asian. And therefore, we submit that Rule 3 was interpreted correctly and discerns the true intention and purpose of the rule makers. And turning to the next point, we submit that Ms. Tangs had no close connection with the country of Duriano. In jurisprudence held that there is a distinction between legal citizenship and nationality. In the 1999 CAS advisory opinion of International Baseball Association at paragraph 27, the panel said a person may have 2 or more legal nationalities, but every athlete can only have 1 sporting nationality. And Mr. Arbitrators, essentially what this thing is that sporting nationality can be said to be the genuine sporting allegiance of an athlete to the country. And in the CAS 2000 case of Mr. Angel Perez versus the IOC at paragraph 17 through 20, the tribunal cited the Notenbaum case. And in that case, Mr. Notenbaum, who was a German national, had settled in Guatemala, and after the beginning of the Second World War, visited Europe, and on a visit, he obtained Liechtenstein nationality and returned to Guatemala in 1940, less than a year later. And when Liechtenstein claimed restitution and compensation from the government of Guatemala on the ground that Guatemala had acted towards Mr. Notenbaum in a manner contrary to international law, the court held that Mr. Notenbaum's nationality was not based on any prior genuine link with Liechtenstein, and that the sole object of his naturalization was to enable him to acquire the status of a neutral national in time of war. And in the present case, Ms. Tang's, we submit, does not have a genuine or authentic sport nationality, even though she holds Doriana citizenship. And this is because at paragraph 32 of the record, she had recently moved back to Doriana. And merely because she spent 9 years in the country prior, it does not necessarily establish a genuine sufficient allegiance. For example, in the Mr. Perez case, the court held that he did not have a close connection with the US and therefore did not have a sport nationality, even though he lived in the country for 6 years and held a US citizenship. This means that even if there is an athlete that lived in the country, it doesn't automatically suffice to the requirement of an allegiance in the sport nationality sense. In other words, merely living in the country does not grant a sport nationality. And that was distinct from a legal nationality/citizenship. And furthermore, on the last point, in Ms. Tang's participation in the qualifying games, this resulted in unfair competition. In the 2010 Football Association versus Football Association of Ireland at paragraph 39 through 40, the panel observed, and I quote, "The attempt at Qatar to naturalize Brazilian players in 2004 prompted a reaction from the FIFA Emergency Committee, which decided that a player who acquires a new nationality without having a clear connection to the country involved is not entitled to play for the national team. And therefore, in the present case, if I may direct the panel to paragraph 3 of the record, it states that she is a rising star and an online streamer. And this evidence merely establishes that she essentially engaged in nation shopping, switching alliances to go over to Doriana, sign the contract, and gain fame as a streamer, and this in turn took away the opportunities from a local athlete as well. And we submit that she does in fact have no genuine connection to the country of Doriana. And consequently, I conclude that an athlete with dual legal nationality does not automatically entail a sport nationality. This concludes, unless I may be of further assistance, this concludes my submissions.
I have no questions at this point.
If I may, Mr. President, I just have one clarification for the Council. I am mindful that, Council, you have provided us with a great amount of jurisprudence insofar as the naturalization is concerned. And I'm quite familiar with those cases. You have cited a few past cases involving UEFA, Dynamo, FA against Ireland. If I'm not mistaken, those cases are all in relation to a particular athlete acquiring a new nationality, which means those athletes, they changed their nationality from one to another. However, in this case, this particular athlete, Ms. Tanks, have a dual citizenship. So I'm wondering whether you can be of assistance to us in explaining how those differences actually do not impact or do not will not affect on the legality or the law insofar as the citizenship or the dual citizenship of this particular athlete is concerned.
Thank you, Mr. Arbitrator Gerald, Mr. Tang. The facts of those cases may be slightly different from the present case, but the principles of those cases are still applicable. And for instance, one of the requirements for a close connection is a genuine link and also the altering of the way of life. And so this means what the athlete has done in that particular country in terms of training and in terms of competing, whether they were there training, and that in itself would establish a more genuine connection to the country. And moreover, the jurisprudence is also recognizing that even though merely living in the country does not automatically entail a genuine sport allegiance. For example, if a resident lives in Malaysia and acquires PR or citizenship, there may be some evidence to prove that they may not have an allegiance to the country necessarily. And these are the general principles that were reflected in those cases, such as in the Mr. Notenbaum case.
Thank you.
Thank you. I conclude my submissions.